Welcome to Employee Termination Tips. My name is Christopher Neufeld of Neufeld Legal. And in this particular video, we're going to be discussing salary add-ons versus add-ins. And I know it's going to be a very technical, legal-specific, jurisdiction-specific video. But nevertheless, you have to understand, if you've left your job, you've lost your job, you've been fired, terminated, or quit, and you're trying to determine whether or not you are owed money, and you were paid on salary as opposed to being paid on an hourly rate, where the facts actually apply, this can be an incredibly important video to you, given the severity of the mistakes and the consequences financial to yourself that really need to be addressed. So let's dig into what we're talking about. What we're talking about is a salary situation where you have additional components in addition to the base salary that are provided to you. So what we're talking about is aspects such as vacation pay, statutory holiday pay, overtime pay, and other elements of pay that are beyond the base salary. And what we're looking at is, depending on the jurisdiction that you're employed in, be it a province or a state, you need to be looking at the laws of that specific jurisdiction and determining and understanding whether those salary components can be an add-on, which means they have to be tacked on above and beyond your salary, or if it is legally permissible to have them as an add-in, which means that they can be incorporated into your salary. And this makes a lot of difference, because if you're having only add-ons permitted, or certain elements must be add-ons versus add-ins, that means these numbers are going to be above and beyond your base salary and have increased your pay over all the years of employment. Conversely, where it is permissible, and this even some government websites, they seem to be, in my opinion, really skating the line on it. But I don't practice in those jurisdictions, so I can only offer my opinion. They do allow for add-ins to salary, which seems sort of problematic in the sense that you start including stuff into salary, which really is something that should be a component part above and beyond. And how does this actually work? Well, if your jurisdiction, for example, the province of Alberta, specifies that salary is a distinct and separate component from vacation pay, from overtime pay, from general holiday pay, or otherwise known as statutory holiday pay, those components are properly add-ons. As such, at least in our professional estimation, and as supported by case law, which we will put into the comments of this video, and the links, what happens is that those additional components need to be paid above and beyond. Conversely, in those other jurisdictions where you're allowed to do add-ins, you get different numbers. And what does this mean? Well, let's say, for example, just with respect to your standardized vacation pay and your standardized general holiday pay being at 6 and 4% of wages, but for sake of argument, we're going to not even look at the other components of wages. We're not going to look at the other aspects of inclusions in the vacation pay that are required under the Alberta law. Simply by doing that, let us say that somebody is having a salary of $50,000. If that person has a salary of $50,000 and the law allows for add-ins, that person will net $50,000 under the law, because they will add in, presumably, $3,000 for vacation pay and another $2,000 for statutory holiday pay. Now, if you have an add-on situation, which appears to, in all circumstances and case law would support it to be the case in Alberta, you have to take that $3,000 and $2,000 and put it as an add-on, which means that you not only collect on the salary the full $50,000, but you also collect on the $3,000 and the $2,000. So your net return is $55,000. As you can see, there's a significant difference. We're talking about $5,000, I should say. And that with the add-on scenario, you're receiving that additional 10% of your base on top of it, being $5,000. And given the fact that so much payroll software is either overly uniform and generalized, or practices are such that they try to reveal stuff or document stuff and then claw it back, you really need to be looking and analyzing properly to determine whether or not you are entitled to that additional $5,000 in the example. Because if you're not being paid that, and especially if in those jurisdictions where those amounts accumulate in trust and are earned money, that can provide a significant amount of money. Because if we're just going to take, for example, somebody who has worked for, let's say, 10 years at a company, making $50,000 every year, and at the end they're terminated, and they've accumulated year after year, for just sake of example, $5,000 in the $50,000 salary, that's $50,000 in earned money that is sitting in trust with the employer and is due to the employee. Important information, important knowledge that has to be tackled because that is owed money. But it's critical is whether the legislation that governs these statutory minimums and governs these payments is an add-on versus an add-in scenario. Because if it allows add-in, that employee would not necessarily be entitled to the money. However, if it's an add-on, they would be entitled to the money. And given what we have seen and what is all too common in the processes, in add-on jurisdictions, there is all too often a reliance upon add-in processes. So it should have been add-on, it's applied add-in, and who loses? The employee. Who gains? The employer. So you have to look at this stuff, you have to explore it, because we're talking about money that is statutorily mandated, earned, and legally owed to those employees. And all too often, just because of the systems and the lack of knowledge and the lack of application of a specific statute to the software and the practices, people are getting shafted by allowing themselves to operate within an add-in structure where it should be an add-on structure. Thank you.